because there is no way, they've already tried it twice, that this is going to be pinned on Karen Reed. Karen Reed didn't do it. The jury's seen it 2 times. We saw it. She didn't do it. Somebody else, something else happened here. And y'all could be the only ones who could be hiding the truth. Come on, man. The Commonwealth witnesses vigorously dispute defendant Karen Reed's allegations and will defend against these false claims. The Commonwealth's defense will include motions to dismiss, potential removal of these claims to federal court, oh my, as well as counterclaims against defendant Reed and third party Aidan Kearney, aka TB, we're going to call him, put some respect on his name, also known as Turtle Boy, for defamation and other torts that they have committed individually and in concert. The Commonwealth witnesses, however, should not be forced to litigate these false allegations and their own defamation claims in this pending lawsuit brought by the family of Officer John O'Keefe against defendant Reed and 2 other defendants for their role in causing the death of Officer John O'Keefe on January 29, 2022, the wrongful death action. Bringing defendant Reed's proposed cross claims into this action, along with Commonwealth's defamation and other tort claims, is procedurally improper at this stage and will substantially increase the claims, parties, and factual disputes and legal questions in this case without any evident economies of scale. Economies? Moreover, the plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If the defendant, Reed, is permitted to file these claims relating to her criminal prosecution in this case, the motion practice on her pleadings will likely take months. We're not going to hear about this case until next year. So what are we complaining about? Then, if the defendant Reed's proposed cross claims survive dismissal, the Commonwealth will file their own counterclaims against defendant Reed and Turtle Boy in this action. Those counterclaims could again trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on the defendant's proposed expansion of this case. Accordingly, defendant Reed's motion should be denied, and she should be directed to file her proposed pleading, if at all, in a separate action. In that separate action, depending on what claims survive the dismissal, it may be appropriate for the parties to consolidate the cases pursuant to Rule 42 of the Massachusetts Rules of Civil Procedure. So they're saying we can consolidate this, but we just don't want to consolidate it here.